But it's certainly a trust estate planning exercise gone terribly wrong. We start with what we've started with all the time today. We start with the trustee company of the family trust. Now, this was an estate planning exercise between mum and dad. As seems to be the case in these ones quite regularly, dad went first. And under the estate plan for dad, he gave all of his shares in the trustee company to mum. And then there was separately a principal power. And the principal power, we probably glossed over that a little bit today, but the principal power being that whoever was the principal had the ability to hire and fire the trustee. And the principal power had two things in relation to it. Firstly, it said that they'd amended the documentation to mandate how the succession of that operated. And the succession was that it went to mum, and then it went to mum's legal personal representative, LPR. The other thing that it said was that the principal could not be the trustee. So the principal could not be the trustee. Dad's argument was, well, look, I really see this as a family trust. I want it to be jointly controlled by my two sons, and I want my two sons to then manage that structure for the wider family group. So mum and dad have decided that under their will, they're going to give their shares in the trustee company to the two sons. However, mum, under her will, only put son 1 as her LPR. And again, we go back to this mantra of reading the deed. No one had actually read the trust instrument. So, chain of events was this. Mum passes away, yes, the shares go there and the brothers are meant to be at the table. Son 1 reads the trust instrument, or probably his decent lawyer read the trust instrument, said, hey mate, you know what, you are the legal personal representative under mum's will. You are the principal of the trust. You may decide who that trustee company is. The only thing you cannot do is you cannot appoint yourself as a trustee. And son 1 says, well, you know what? I'd like full control of this trust. I'd like to be able to take all the assets of the trust and do what I wish with them without having to refer to my brother, who I don't get on with. What I will do is I won't appoint myself as the trustee. What I will do is I'll set up a new trustee company with 100% of the shares in that company with me, and I will be the sole director. And then once I've taken those steps, and there's specific tax and stamp duty rollovers available to let me do that, once I've taken those steps, I'll get all the assets out of the trust and give them to me, and my brother can make his own arrangements. Brother 2, son 2 got word of this, tried to challenge the arrangement and said, well, there was effectively a fiduciary duty, you know, even though it said the principal couldn't be the trustee, well, surely that also included that the principal couldn't set up a sole director, sole shareholder company and just sidestep the issues. And the Supreme Court said, yes, you're right, son 2, that's not fair, you win. The Court of Appeal said, yes, you're right, son 2, that's not fair, you win. The High Court said, you know what, this wasn't a very complex trust instrument. Mum could have quite easily got someone to read that for her to tell her that all of her objectives would be unwound if she only appointed son 1 as an LPR. We think that what son 1 has done is entirely in accordance with the trust instrument. Son 1 wins, not son 2. So the whole arrangement was held to be valid, and son 1 took the money and ran, literally, and son 2 was left to make his own arrangements.